Are there any laws in your state that can be utilized against false allegations of abuse?
In Pennsylvania, there's a law called the Dragonetti Act, or I should say it's an act called the Dragonetti Act. That act has two elements: wrongful use of civil proceedings and abusive process. This law was created generally for frivolous medical lawsuits, where somebody would file a frivolous medical lawsuit against a doctor just to collect insurance money. It can be used, and I've seen an example of it being used by a father who used this law to sue the other parent because of a frivolous protection from abuse order, and that father won, or should it was settled, and that father collected all the money that was provided in the lawsuit itself.
Great. How is your proposed law different than Dragonetti?
The Dragon Eddy does not take into consideration the ongoing allegations in family court. And the example that I have is a real life example that I've read through the transcripts on this. So, under the Dragon Eddy, a father was falsely accused of child abuse. The mother got a PFA. And because of that PFA, the father wasn't able to see the child for a period of, I think, like 10 days. Under the Dragonetti law, the father was able to recover all the money spent on the initial PFA hearing. However, this allegation of abuse kept occurring in child custody, and it was tens of thousands of dollars that the father had to spend to defend himself in child custody, the psych evaluations. This new bill covers basically a blanket every time the false allegation is used, or in court, or any type of psych evaluations the parent has to go through from A to Z. Any type of therapies the child has to go through, including the reunification therapies that the child has to go with, the alienated parent. This new bill provides relief in all these aspects where the Dragonetti Act really doesn't touch base on any of those, especially the emotional damages done to both the parent and the child. That's the biggest portion of this bill that is covered, is that emotional aspect of the children. Sometimes the children are removed at school and taken into protective custody, and the parent arrives at school and their child is nowhere to be found. The sheriff just serves them with a order saying they can't see the child. So it's very damaging to both the child and parent to be put through this. And this bill protects or adds relief, tons of relief for that emotional damages done to both the child and the parent.
Yeah, and it's one thing for an adult as a parent to uh, understand what's going on, but these children don't understand what's going on, and this is where it matters most is what we actually are doing to the children. What are we saying to these children in doing these different actions? How does your proposed law protect actual victims of abuse?
That's a really good question, and that's what I put a lot of emphasis on in this bill. So in this bill, there's a three-tier, I call it a three-tier qualification, um, basically segments. So the first tier is that the initial proceeding or the allegation of abuse has to be dismissed, or it has to be unfounded, or not found to be guilty. You can't have a parent come back and use this bill if they're found guilty of child abuse. So it has to be not guilty. It was dismissed, and there's no evidence basically to substantiate those allegations of abuse. The second tier is that there can't be any proximity measure or a safety net in place. A lot of times during a protection from abuse hearing or restraining order, in Pennsylvania we call it protection from abuse, in other states they call it restraining order. Instead of going to a full-blown trial, both parents will agree to settle. And as a part of that settlement, one parent might say, oh, we have to meet at the police station to exchange custody of the child, or one parent can't be around 200 yards of the other parent in public. That's called a safety proximity measure. And most of the times, when the PFA is quote unquote dismissed, a safety proximity measure is put in place. So, in order for a parent to use this bill, there can't be a proximity measure put in place in lieu of going to trial. the original hearing has to be dismissed. It has to be found not guilty. There can't be a plea bargain, in criminal court stating that, oh, the parent can have XYZ time or supervised visits. It has to be straight up dismissed without any proximity measures put in place. And the third tier, which is the most important, which I found through a former prosecutor, is that the initial hearing, even though it's dismissed without a proximity measure put in place, there has to be lack of evidence that the abuse actually took place. And a prosecutor told me the story of that when one parent's arrested for child abuse or some type of domestic violence, the other parent, because of the trauma bond, will visit the incarcerated parent in jail. And the incarcerated parent will be like, "Oh, dismiss the case. Don't go to the PFA hearing or withdraw it. I'll change XYZ XYZ." And sometimes the parent that filed the protection abuse order will just not show up. They will be so twisted around and manipulated around of not showing up and being told all these lies that they don't show up, and the PFA or restraining order is dismissed or the criminal charges is dropped.